with State of Ohio versus Moses Payne. It's 18CA011383. Both parties are present and prepared to argue. So each of you will have 15 minutes to present your argument. The appellant may reserve up to 5 minutes for rebuttal. I'm going to keep track of the time, so if you're going to ask for rebuttal time, let me know and I'll keep track of that for you. We've read the briefs and are ready to proceed if you are, counsel.
Very well, thank you, Your Honor. Morning, Your Honors. May it please the court, my name is Attorney Jason Harless. On behalf of the appellant in this matter, Moses Payne, I would like to reserve 5 minutes for rebuttal. On March 21st, 2018, around 1 a.m., Moses Payne was driving home from Detroit to Cleveland on the turnpike. While on the turnpike, his car became essentially inoperable, running out of gas, coming to a stop on the side of the road. When he stopped on the side of the road, he had a decision to make whether or not to walk for gas or wait for help. He began to walk for gas, realized it was too dark to walk on that section of the turnpike, especially that time of night, returned to the vehicle, and consumed a bottle of beer while in the vehicle.
Let me stop you there. When you said essentially inoperable. Could he start the car or not?
It's indicated in the record, Your Honor, that at one point he testified that the car turned over, started, and then immediately stalled. So
anything to indicate it moved at all?
I don't believe that the record indicates that it moved. I think that it says that it stalled immediately thereafter moving, or thereafter attempting to start it.
All right, thank you.
After he started the vehicle and it stalled, he became frustrated and then consumed another bottle of beer. At that point, shortly thereafter, a trooper approached the vehicle, noticing that the vehicle was stranded, attempted to give him help as the trooper was discussing helping him, essentially transporting him to a gas station to buy a gas can and some gas. The trooper eventually detected the odor of an alcoholic beverage coming from his persons. At that time, the trooper began to do field sobriety tests and take him through the steps of the OBI, the standard OBI procedure. When the trooper got him back at the station, he administered a breath test. The breath test resulted in a .094 reading, being .014 over the legal limit. At trial, it was discussed when he had essentially consumed beers, all right, that being at two specific points. One in Detroit before leaving Cleveland, again before he started the vehicle or attempted to start the vehicle, after he started the vehicle, and then there were no more beers consumed after the vehicle, or there was a beer consumed after he started the vehicle, and the trooper approached and he was arrested for the OBI. I think that in the trial court's opinion, he operated the vehicle only by starting it, turning it over, and then installing, and I think that will amount to manifest injustice in that the trial court lost its way in deciding this case. I believe that looking at all the elements of the OBI, the two main points that are imperative for the court to consider are: was the vehicle operated, and was the driver at or above a .08 at the time the vehicle was operated? I think
is a person operating a motor vehicle if he's sitting behind the steering wheel with the keys in the ignition under the law?
I don't believe so, Your Honor. I believe that in this particular case, because the vehicle was inoperable, whether or not he had the keys isn't so much the issue as whether or not the vehicle was operable. I think it's a legal impossibility to operate something that is no longer operable. In my brief, I cited cases, similar cases in other jurisdictions where a vehicle was stuck in the mud. The vehicle was deemed to be inoperable because it couldn't be moved.
So does the test the potential to cause the vehicle to move? If somebody has the potential to cause the vehicle to move, is that operating a vehicle?
Yes, Your Honor. I believe that if the driver is in the position to operate the vehicle and exercise that dominion, that level of control over the vehicle to the point at which it could be operated, then that could be deemed operation of the vehicle. However, again, in this matter, there was no possibility that he could possibly operate that vehicle.
He started it, but he didn't move it at all.
Right.
Basically, is what you're arguing.
Right, and I would liken this to a man working on a car in a garage. He engine, the vehicle, say it's up on jack stands. I don't think that would amount to an OBI. Cars in the air can't go anywhere. In this situation, there wasn't enough fuel to power the vehicle to go anywhere.
Well, counsel, the vehicle got to where it was, correct?
Correct.
Was there any dispute in the facts as to who drove the vehicle to where it was?
No,
So it was operating at one point.
correct.
Didn't the trial court's decision kind of just basically amount to the fact that the trial judge didn't believe your client in terms of how much he had to drink and when?
No, Your Honor, I believe that the trial court's opinion was clear in that it stated that at some point he rose over the limit as indicated by the blood alcohol test, and that specifically when he started the vehicle was when the operation occurred. However, a reading of the transcript will show that a beer was consumed after that point at which he had started the vehicle. And so there, you know, the vehicle, again, that alcohol limit was, again, increased. And I believe that with the strict per se limit of 0.08, the court needed to see that the alcohol limit was above that at the time of operation. So if the court is deeming the point at which the vehicle started as the operation of the vehicle, they're not considering the fact that he consumed the beer after that operation occurred. The court also, in their opinion, looked at the blood alcohol chart. I don't believe that any evidence was advanced at trial as to whether or not this blood alcohol chart was accurate. I think that this blood alcohol chart doesn't take into consideration a lot of things, what type of beer it was. I mean, these days we have beers that are 8%, 3%, 0%.
Was that blood alcohol chart admitted into evidence by anyone?
It was not.
Referred to by anyone?
No, I don't believe so, Your Honor. That said, I don't believe that the trial court properly considered the evidence and therefore, again, lost its way in doing this extraneous research to discover what the blood alcohol content may have been. I know that it does consider the weight of the appellant in this matter and the fact that he's a male and the number of beers consumed. But again, we have no indication of what the alcohol content was of that beer that was consumed or when it was consumed. And I think that very easily it could be seen that consuming the beer after the attempt to start the vehicle raised his limit above that 0.08. That said, I think that again, the trial court lost its way in deciding this case and essentially attempted to justify the OBI by that small window of operation. And I think that in doing so, they clearly found that the defendant's or the appellant's testimony in the matter was credible on some limit, on some level. He does say that, you know, the beers were consumed. I know that the trooper's testimony somewhat disputes the appellant's testimony in that beers, the number of beers that were consumed, where they were consumed, whether in Detroit, whether he split one with the person he was riding with or not. But in the end, the court considers the fact that he consumed beers while in the car, and again, the operation occurred when the vehicle started and then stopped immediately thereafter.
So back to Judge Callahan's question, was there evidence, did the court find that there was enough circumstantial evidence or evidence of any type that your client was intoxicated at the point he ran out of gas? Did the court go into that analysis at all?
I don't believe so, Your Honor. I think that because the vehicle was operated, the court solely looked at the fact that the operation occurred on that level of the car vehicle starting, and then immediately thereafter, it was, you know, not usable at that point. It was not operational.
What was the time between the actual driving of the car, you know, before it ran out of gas, and between that time and the time when the police officer arrived?
Again, it's somewhat in dispute. A reading of the transcript will show that the appellant asserts that at 1 o'clock he ran out of gas. He was there for about an hour, both between fiddling with the car and drinking the beer. But then the trooper, there was testimony that he said, I've been here for about 10 minutes. That said, again, the court's opinion essentially states that the operation was based on that short window and doesn't make a finding as to whether or not that time, what time frame was accurate.
So if it was 10 minutes or 1 hour, officer observe anything other than the odor of alcohol that would indicate your client was intoxicated?
Certainly, upon approaching the appellant in this matter, the trooper did a series of field sobriety tests, all of which yielded a possibility that he was intoxicated. With regard to those tests, I think that whether or not those tests exhibited anything, I think that the blood alcohol content was observed through the data master test, being that it showed it was over 0.08. In this case, really comes down to a level of was that operating a vehicle or
The
not.
BAC case.
Correct.
You're at 5 minutes. Do you want to reserve the full 5 or do you want to continue?
Yes, Your Honor.
All right, you'll have 5 minutes then for rebuttal.
Thank you.
All right, counsel, you'll have 15 minutes then.
May it please the court, I'm Farah Mecca and I represent the state of Ohio, and the conviction in this case should be affirmed. Before I get to the major points of my argument, I would like to address a couple of matters that came up during counsel's argument. The incident took place on March 12, 2018, according to the record. And if I may, as it relates to the question regarding whether or not the vehicle moved, in the transcript at page 44, there is the testimony of defendant, which, if I might, I'd like to read it for the court. This is the defendant answering the question when, or referring to when he ran out of gas. Now, he said, now what am I going to do? I sat there for 2 minutes. I got out because I work on cars. I get out, I go jump on the back of my bumper. I bounce my bumper like this and let the gas flash up on the fuel pump. Car started. I said, cool. I put it in gear and made it to 2 feet. It cut off. I said, damn. I get out, I tried it again. I bounced on the bumper again, indicating it started up again. I pulled off, made it about 2 more feet. I said, damn, ain't going to work. So according to the defendant's own testimony during the trial, he did, after the car initially ran out of gas, have the opportunity to operate the vehicle, moving it 2 feet in distance at 2 times. Now going to the major points of my argument. The evidence in this case does not weigh heavily against the conviction. The state in its brief did misstate the standard and argue the wrong standard, and so today I'm going to present the correct standard. And in overturning a conviction as against the manifest weight of the evidence, this is a discretionary power that is used in an exceptional case. As such, deference is given to the decision of the trier of fact. In this case, that's the trial judge. This is not one of those exceptional cases. As the court has already indicated through its questions, the defendant was not found to be a credible witness by the trial judge. The trooper's testimony, mind you, we have a trooper who is a 12-year veteran of the Ohio State Patrol and a sergeant. And his testimony is more credible and is credible as opposed to the defendant's. The trooper testified that he observed the defendant on the side of the road at around 2:11 a.m., that he saw that he looked like he needed assistance. As he pulled up to the vehicle with his lights flashing, he observes that there's nobody outside of the vehicle as he's pulling up. Then he actually observes the defendant open the driver's side door and exit the vehicle and begin walking towards the patrol car. In his contact with the defendant is agreeable to the assistance that the trooper is offering to him. He agrees to a pat down, and the trooper observes an odor of alcohol. He also observes a slight slurred speech from the defendant. He offers to allow him to come into his patrol car. He continues to smell that odor of alcohol, and then decides to inquire into whether or not there's a potential that this individual had been operating a vehicle while under the influence. When he asked the defendant about whether or not he's consumed any alcoholic beverages, he admits that he had a beer. At that point, the trooper asked the defendant if he would be willing to submit to standard field sobriety test, which he does. The court also indicated in its questions previously as to whether or not there was other indicia of the fact that the defendant may have been under the influence of alcohol, and there was. In addition to the slurred speech and the odor of alcohol, when the defendant did the standard field sobriety test, he failed all 3 of the tests. There are 4 or 6 clues on the HGN, which the trooper testified very clearly on direct that indicates an 80% probability that the defendant was over the legal limit. He had 5 clues on the walk and turn test, which the trooper again testified clearly on direct examination that is a 93% probability that the defendant is over the legal limit. And then the defendant was not able to complete the one-leg stand because he put his foot down 4 times, so the trooper stopped it. All of those are indications of the fact that he was under the influence of alcohol.
Now, as to the slurred speech, as I recall, didn't the court indicate that he did not, that the court did not hear any mumbled words or slurred speech on the video?
That's correct, Your Honor. On the video that was played during the trial and in his decision, the trial judge indicated that he didn't hear any slurred speech. The importance of the slurred speech, though, is that is what the trooper observed at the time on the road. That is what's feeding his investigation and his determination that he needs to, again, look and inquire further as to whether or not this person is intoxicated. Another important point, when the trooper approached and made contact with the defendant on the side of the road there, the defendant volunteered that he had only been there for 10 minutes, which indicates that he was driving that vehicle and that it was operable and that it was on the freeway just 10 minutes before the trooper approached him. In his testimony, the defendant's facts regarding the beers and several other matters was wholly inconsistent. So let's talk about the beers. Initially, the trooper testifies to the fact that when he made contact with the defendant and asked him about the number of beers he drank, the defendant said in Detroit he drank 2 beers with the passenger and the passenger drank 1. Then he quickly turned it around and said the passenger drank 2 beers and he drank 1. This is all while he's still talking to the trooper on the side of the road. Then you have the trooper's testimony that upon an inventory of the vehicle, he observed 3 unopened beer bottles in the vehicle. You fast forward to the defendant's testimony on direct examination, and he changes his story from what he told the trooper at the side of the road on the night of the stop. He says in Detroit he had 1 beer with his passenger when they made it to her destination, and that she had 1 beer as well. He specifically states that he drove home from Detroit with 4 beers in the vehicle. Then, later, on cross-examination, when asked about how many beers were left in the vehicle when he was stopped by the trooper, the defendant states on cross-examination that there were 3 beers in the car. So he's totally inconsistent in terms of his own testimony. He was inconsistent when he was on the side of the road that night. He's inconsistent within his testimony there in the trial. Then he says within his direct examination testimony that he doesn't drink and drive. But then he immediately goes on to testify to the fact that he had 1 beer with his passenger, which he gunned, and his passenger had a beer. And that when he arrived at his passenger's destination, it was between 11:10 or 11:20-ish at night. He sat there with the passenger 10 minutes drinking the beer. He went around the corner to grab a taco after that, and then got on the freeway back to Cleveland at 11:35 p.m. Based upon his own testimony and his own timeline, that would mean that the defendant was driving within 5 to 15 minutes after drinking a beer on the highways. So his own testimony is inconsistent. He was definitely drinking and driving at that point.
Driving after drinking a beer isn't necessarily OBI, is that correct?
That's correct. Yeah.
You're just saying that's one of all the factors.
Yeah, that's one of all the factors that show that his testimony is inconsistent and that he is not a credible witness. And then again, you have the testimony of the trooper observing 3 beers in the vehicle, the fact that he encountered an individual who smelled of alcohol, who said that their car they had just been there for 10 minutes, and that the trooper saw nobody outside of the vehicle, and he saw the defendant exit the vehicle from the driver's side door. The defendant's testimony was that he had been standing out for a period of time because he had to go to the bathroom after drinking those 2 beers, and that he walked up to the trooper having not exited his vehicle, and that he meant that he was only standing outside for 10 minutes. That's inconsistent with what the trooper's testimony was. The trooper is a more credible witness, and so the state has met its burden regarding the operation of the vehicle, because the only way for this court to find that the evidence weighs heavily against the conviction is for this court to believe the defendant and find him a credible witness. The trial judge did not find him a credible witness, and this panel should not either.
Let me ask you something, counsel. I'm going to kind of maybe segue here into the second assignment of error. I was noticing in reading the trial court's rationale for dismissing the, just the general A1 OVI. It said a nondescript odor of alcohol, so apparently while the trooper testified to alcohol odor, didn't say moderate, light, heavy, anything like that. As Judge Teodosio said, mumbling a few words, the court didn't notice any mumbling. His admission of one alcoholic drink in Detroit a couple of hours prior, and then failure of the field sobriety tests, which kind of discounted, it says has some value but not a lot. Based upon what we know that this court observed or found, because the judge put it in writing here, how do you even get to the trooper being able to request field sobriety tests? And I'm circling around to, should there have been a suppression filed in this case?
Right. Well, I mean, the standard for whether or not the failure to file a motion to suppress is that there's a reasonable probability that the motion would have been granted. And there was not a reasonable probability here.
Kind of sounds that way from what the judge wrote.
Well, what the judge wrote is looking at a different standard. The judge is comparing that to the beyond a reasonable doubt standard, which we know is a much higher standard than probable cause in a motion to suppress. And so given the facts that we have of impairment and the observations that the trooper made, the motion would not have been granted. There was sufficient evidence to meet that much lower threshold of probable cause. Now, also to that point, and to the ineffective assistance counsel assignment of error, this defendant was not prejudiced based on the decisions or any type of ineffectiveness of his counsel, of his trial counsel, because he was found not guilty of the A1A charge. The court does specifically state in its decision, the trial court, that there was not enough evidence to get to that reasonable doubt, beyond a reasonable doubt standard, and so he found him not guilty of the A1A or impairment OVI charge. But the judge then goes on to find out that there was sufficient evidence to prove beyond a reasonable doubt that he was operating the vehicle on that night and that he was over the legal limit because there was an undisputed .094 blood alcohol content test that was admitted into evidence.
And going back to my question, how would they have gotten that test had it been suppressed, or had the trial court found that the trooper never basically had cause or suspicion to allow him, I'm not saying that right, I'm sorry, didn't have reasonable suspicion to even ask him to perform the test.
So,
And I recognize you're right about the different standards.
okay, so, and that will go back to that point. That's not the standard under which the court was looking at the evidence. And then also important to note is it was not suggested in the appellant's brief, nor did trial counsel try to suppress the actual breath test. So our argument is there was not a reasonable probability that the motion to suppress would have been granted, and the breath test still would still be there. I think there's definitely enough evidence to get beyond the probable cause standard for the motion to suppress, and you still have the breath test because the defendant did not challenge that at the lower level. So given that, the state would ask that the court affirm the conviction of the trial court because the defendant was definitely not a credible witness as determined by the trier of fact at the lower level, and just a review of the record itself. And then also because there is that undisputed blood alcohol content of .094 that did come into evidence, and that based on the testimony of the trooper, the court could find and did find that even though it was circumstantial evidence, that because the trooper found him 10 minutes after he stopped on the side of the road, he was operating that vehicle while he was over the legal limit operating. And then finally, there was no prejudice to the defendant by the behavior or the conduct of trial counsel because he was found not guilty of the impairment charge, which was clearly the weaker charge, and so he was not prejudiced in any way. Thank you.
Okay, thank you. You'll have 5 minutes for rebuttal.
On a couple points, whether or not the vehicle was inoperable when the vehicle was operated again, the trial court's decision seems to indicate that beers were consumed after each attempt to start the vehicle, being that there were 2 attempts, being that 1 beer was consumed. Or actually, I believe the opinion says before, the beers were consumed before. However, the testimony on pages 46 and 47 from the appellant indicate that the final beer was consumed and no more attempts were made to start the vehicle. I really, again, can't stress enough that this comes down to an operability of the vehicle question with regards to the first assignment of error. The second assignment of error being the ineffective assistance of counsel. In this matter, the case was tried to the bench, where I think that there's a serious question that should have been posed to a jury. I understand that there's a standard that he has to show abuse prejudice. Again, coupling that with a motion to suppress or lack thereof, I think that the totality of the circumstances would show that he was prejudiced. In fact, that the breath test had a possibility of being thrown out based on the fact that the trooper initially didn't even observe that there was alcohol on his breath and attempted to help the man by putting him in his car and taking him to a gas station. It was only that close contact yielded the result that it did.
Well, was the car partially on the road, or was it totally, how was it parked?
The car was parallel to the road on the side of the road.
So it was properly parked?
I believe so, Your Honor. I don't think there was any indication that there was any parking infraction in this matter. But it really, again, comes down to whether or not the vehicle was operable. I think that the case law, it's on point.
What about the state's point that it was moved 2 feet on 2 occasions per your client's testimony?
Again, throughout the transcript, whether or not the vehicle was moved 2 feet on 2 separate occasions or not, there's testimony, again, on pages 46 and 47 of the transcripts that indicate that the final beer was consumed after moving the vehicle. I think that even if we consider the trial court's pictograph with the blood alcohol levels on it, I think the final beer that was consumed, according to the appellant in this matter, was enough to put him over the threshold. I think that being from a .08, a strict limit that has to be proven.
I understand that argument, but are we speculating that, or is it, it's not part of the record, I'm sure. There was no testimony on that, was there?
There was no testimony other than what the testimony, or other than what the court put in the opinion, which indicates that the blood alcohol level would have had to have been higher. But in any event, I don't think the default should be to find him guilty of it. I think that, again, and on to the second side of argument, had this gone to a jury trial, I think that the results would have been different. Had this motion to suppress been filed, I think there's a decent shot that the motion would have been granted in this court. Obviously, the trial court indicated that the field sobriety test didn't indicate there was sufficient evidence to indict him or to convict him on that charge. So I would ask that this court reverse the conviction in this matter based on the inoperability of the vehicle and the ineffective assistance of counsel.
All right, thank you both for excellent arguments here. The court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail each of you a copy on the day the decision is released. You could also check the Supreme Court of Ohio's website where the decisions are posted. But I want to thank you both for appearing and arguing this morning.
Thank you, Your Honor.